and they are novel issues upon which the court system must make some pronouncement. There have been no such pronouncements before. The card reader was used for the first time, and now the Supreme Court has now given the law, which is, if it is not part of the Electoral Act, it cannot be the basis for setting aside an election.
But what do you make of that?
So you're looking, sorry, Chairman, that means we're looking at the future now. We have subsequent elections coming.
Law reform.
Good.
Law reform. The simple thing is this. Let us tell the National Assembly that they should start doing their work.
What if they do not agree that the card reader should be a part of it?
If they don't agree,
yes,
then they amend the Electoral Act they put it there specifically. It must be specifically stated that the card reader is not part of the system. And then they thereby okay, let me take it from this perspective. The Supreme Court has now said, okay, look, you have rules, you have directions to guide you. It doesn't form part of the Electoral Act. Which more or less has constitutional flavor. It's a very strong act. Now, and for it to be amended is Herculean. Now, the Supreme Court has made a pronouncement. If the National Assembly is of the opinion that no, that card reader is now part of our system, we're not going to do away with it, then it's time for them they can overrule the Supreme Court. That is the checks and balances in the system. They can now amend the Electoral Act to specifically state that the card reader has come to stay. If there is no strict compliance with the provisions relating to the card reader, then the election will be nullified.
Do you think that could give us problems? Because first of all, as we stand currently, we know that the Electoral Act talks about no electronic voting.
Yes.
And INEC has been, managing a balancing act, as it were, with this card reader, even the electronic registration as well, and also, manual voting. It's been a very thin line for INEC, and it seems like they've been working on ice. Some people have supported, some people have not supported, and that might be reflected again in the National Assembly, which we're asking to look into this matter. Where do you think opinion will sway eventually?
I think the card reader helped a lot in weeding out, in dealing with the menace of election malpractices. Now you see a more realistic figure coming in from different states, unlike before where you just have some millions of people, ghost voters. So you cannot reasonably, no reasonable person, even those sitting at the Supreme Court anywhere, will just say, we don't want. That's not what the Supreme Court has said. Now, the opinion of Nigerians would most probably lean more towards keeping the card reader in the system. But what we are saying is that in order for it to work fully as envisaged, it has worked well for us. You don't throw away the baby with the bathwater. So the only thing left to be done now is for the Electoral Act to be amended to reflect the fact that, look, where there is no compliance with the directives as per the use of the card reader, that election will be nullified. Okay. Once it is put in the law, that ends the problem.
Well, speaking about how to correct, if I could use that word, this kind of scenario such that you don't have a lot of doubts with the public. The CJN's comment where he did note about public complaints of conflicting judgment in the Court of Appeal. And then he also drew the attention of 2008 when retired Supreme Court Justice Nikki Toby did suggest that immediately a decision is given in one division, it should immediately be sent to the other divisions without delay. Because many reference this when Ambode versus Agbaje's case, and they thought, why couldn't others have seen what transpired there and perhaps serve as some sort of precedent? You think that will help in any way?
Well, it should help. In fact, that should be the norm. Unfortunately, scholarship has taken sail. I remember when I first got into practice, there was a particular judge, Justice A.L. Balogun of the High Court in Lagos State here. Whenever a decision comes out of the Supreme Court, Court of Appeal, anywhere, a decision of any higher court, he gets it almost by the next day. In fact, the law reporting this thing was not so as good as we have it now. And lawyers like Chief Rotimi Williams and Chief Ganifawa Emi, you know, young ones like us, we will go to that court simply to know what is the current state of the law, because it's always changing. It could change anytime. Now we have better law reporting. We have online law reporting systems all over the place. People can subscribe. There is no excuse for any judge to overlook the decision of a court of concurrent jurisdiction or of a higher jurisdiction. It is true that in the Court of Appeal, that's where it's rampant, because there are so many divisions. And yes, people have varying opinions on very different issues. Usually, it's not in election matters alone. In regular matters, we've always had that problem. The decision of a particular division will be different from that of the other. And when you then say, well, we may not say you can go to Supreme Court and get a final decision. At what cost to the litigants? Yes, the court system needs to, they have to be electronically compliant. So it's not just that, they have to check. Once it is there, it's posted on a particular forum where every judge must have access.
But they don't at the moment.
I don't think so. But that is not, you cannot ascribe that to individual judges in the system. It is part of strengthening the institution that delivers judgments, that the government, and that's what we're saying. What we have today, you have a situation where people just want to criticize the judicial system. Oh, they are corrupt, they are inept, they are this, they are that. Where in the budget, you have a budget where you are giving billions for the renovation of some structures, and the judicial system that has to be strengthened by this kind of law reporting system, you are giving them peanuts. And they are not self-accounting yet, even though on paper, in law, they are supposed to be independent. They are not. The executive still calls the shots.
You know, in the absence of getting that electronic system whereby we can have a network to the extent that they all see the judgment from one court and the other, what are those things that ordinarily the lawyers use? They must cohere. There must be some other things that you see as evidence, and you say, if A, then B,
yes,
then it must cohere, and you have a correspondence.
Yes.
So don't they also follow all of that to the extent that you're getting what we're getting now, something quite different, and you say at the cost of the litigants?
Let me tell you something. You see, election matters. You usually don't have the best from both the bench and the bar because of the time that is fixed for determination of those proceedings. We say judges are like still waters. More often than not, the lawyers must move the judges to see things their own way. And that you must do a lot of scholarship to be able to move a judge to see things your own way. Now, what do we have? The situation has changed. No, advocacy has now been relegated to the background. You have a situation where people take up something that I participated in an election petition. I was guilty of the same thing. You had a situation where you are served with a process, you have to respond by tomorrow morning. And you have like 40, 50 pages. You have to digest the authorities, you have to reply, find authorities. More often than not, what do lawyers do? They just regurgitate what they had before. At times, when the judges are reading some of these things, in particular, there was a case of a lawyer who just filed a process and forgot to remove the name of the parties in an earlier case and just filed it in this case. And that automatically disqualified his client because the process was invalid. He put the name because he did not remember to change the names. It was just cut and paste.
Oh dear.
So now, how then will a lawyer be able to move a judge? The judge is supposed to be there, standing. You are supposed to pull him this way, that way. The lawyers who are supposed to do the help, because of the time frame within which they have to, they can't do it. So the judges, it's garbage in, garbage out. Whatever you give to them, they look at it, and then they just write.
You talked about,
I don't want to give it a name.
You talked about not ignoring the judgment of a concurrent or of a higher court.
Yes.
Let me take you up on the concurrent one. Are appeal courts allowed to differ on a particular issue, so that you've taken into cognizance a concurrent, a judgment from another court of concurrent jurisdiction, but you don't agree?
They are allowed to differ. And that's where the Supreme Court comes in. They are allowed to differ on a particular issue. I mean, that's why I said earlier on that there is no law that says judges can never go wrong. They can go wrong. they are presumed to know all the law, but they may not know all the law. So yes, they can differ, and then you have an opportunity to go to a higher court, which will then look at the different decisions and balance it out on the basis of precedent, that, oh, this is the logic. The moment, one subset of the concept of rule of law is that there should be certainty in the law. What the Supreme Court has tried to do now is to bring some form of certainty in the law. It doesn't mean that that law will remain the same. Tomorrow, the National Assembly can change it and say, okay, the law should be this. And then the Supreme Court would have to apply that law, which may be different from the decision today. So there's nothing that is total. The Supreme Court has not gone out of its way to make what we call judge-made laws. They have only interpreted the law as it is, not as it should be.
All right, fine place to leave it. Mr. John Oloye, the legal practitioner, thank you for coming on today.
Thank you very much.
All right, we'll be back. We've got another matter that transpired yesterday, but that'll be coming up in a moment. Don't go away.